For our case, we have from the United States Court of Appeals for the Fifth Circuit, the case of Anderson Jones versus Elena Perez. This is a case dealing with a search and seizure of a person and arrest. And the question is here about the validity of the arrest because the arrest warrant was based off of incomplete or false information that was made to the judge who signed the arrest warrant. So the question the Court of Appeals is trying to decide is the validity of the arrest because the arrest warrant was based off false information or incomplete information. So we're going to read what the Court of Appeals has to say, so let's get started with this. Dallas Police Detective Elena Perez obtained a warrant to arrest Anderson Jones for murder. In seeking the warrant, Perez did not inform the magistrate about significant problems with the reliability of the eyewitness who identified Jones. After the charge was dropped based on reliability doubts, Jones sued Perez. We must determine whether the arrest violated the Fourth Amendment rights. Leonardo Ortega was closing up the sandwich shop when he worked with two men entered with their face covered. One aimed a gun at Ortega while the other took cash. After a struggle, Ortega was shot. He is pronounced dead. Detective Perez was assigned to the case. Two eyewitnesses told them about a third man involved in the murder, a lookout who stood across from the shop and ran off with the other suspects. Perez's investigation stalled until an anonymous tipster called in with information about the third suspect's identity. According to the tipster, Christopher Miller was bragging about being the lookout. Perez brought him in for questioning. It soon became clear that Miller might not be the most reliable of witnesses. Oh, this should be entertaining. When courts use that kind of language, you know that they're underselling it. So that'll be good. Let's see what they say. It appeared to Perez that he had a low IQ, and Miller explained that he had smoked synthetic marijuana and drunk a few beers before coming to the station. Okay, that's questionable. Miller initially stated he had nothing to do with the murders, but soon began to waffle. He admitted, occasionally backtracking, that he was there that night. He told Perez that two men he often saw selling drugs in an apartment complex near the murder scene had asked him to watch while they robbed the subway. Miller knew them only by their nicknames. Miller's description of the murder was consistent with what the three witnesses said that night. He left the police station. Okay. The next morning, a few officers took Miller and his brother to the apartment complex to see if they could find KT. It's unclear who ultimately made the identification, but the officers soon learned KT was Anderson Jones, the plaintiff in the case. A few officers took Miller to meet him back with Detective Perez. While detained, Jones admitted that his nickname was KT, but denied any involvement in the murder. He said he was with his girlfriend throughout the evening. But when Perez contacted Jones about his supposed alibi, she told a different story. She says she picked up Jones that night from a bus stop near the subway, and Jones was jailed on a drug charge. That does kind of sound suspicious. Perez returned to questioning Miller. He was obviously distressed and threatened to commit suicide several times. He even attempted to strangle himself with his own shirt and had to be restrained. But eventually repeated the story he had told Perez about the previous night, albeit with some difficulty and with the aid of a few prompts. Perez decided that she could conduct a photo lineup to see if Miller could identify Jones as KT. Lines up are always promising. Another officer showed up and showed 6 photographs one at a time and asked whether the picture killed Ortega. The 6 photographs one at a time is not really ideal. Normally you put them in like what's called a 6-pack so you can see all 6 at the same time. But anyways, Miller answered yes to 3 of the photographs, one of Jones and 2 of the uninvolved individuals. He explained that he thought that the 3 he picked up all looked like the same person. That's great. There were 3 different people, but all looked the same. Perez returned with a single photograph of Jones and said, "Who's that?" Miller asked, "That's KT." Over the course of 2 interviews, a number of inconsistencies appeared in the Miller story. He first said that he was by a sidewalk directly in front of the store, but after he informed Miller that the video evidence contradicted him, which may or may not be true because the police are allowed to lie, he said he was in a parking lot. Though ultimately told Perez that KT and he fled on foot, he initially claimed he drove away from the scene. Despite the inconsistencies, Perez used Miller's statements to obtain an arrest warrant from Jones. In her probable cause affidavit, Perez explained that Miller had confessed to participating in and planning the offense, that Miller stated Jones had shot and killed Ortega, and that Miller picked from a photo lineup as the person who had the gun in the offense. She also stated she had interviewed Jones and he was uncooperative. The warrant was issued to Jones, already detained the day before the marijuana charge was booked, and his bail was set at $1 million. Several days later, a few of Perez's supervisors learned about the handling of the case. They were particularly concerned that Miller had selected 3 of the 6 photos he was shown in the initial lineup, and that Perez had corroborated the lineup by showing Miller a single photo of Jones. Yeah, that's not really the greatest photo identification I've ever heard either. Also, incidentally, as a photo lineup, it's kind of prejudicial to show all 3 suspects in the same lineup. What you would ideally do is you'd show each suspect individually in their own lineup. So you'd have to find like people that look familiar. to do their own lineup. So it's not great the way that this was done here. The Dallas Police Department investigated Perez's handling the case. It determined she had improperly conducted a one-photo lineup, yes, and she had inaccurately and incompletely information in the probable cause affidavit, yes. The deputy chief testified with a lineup in which informant selects half the pictures is basically null and void. Yeah, I tend to agree. And it was a mistake to put all three in the same photo lineup. So that was not good practice. It's, bad practice. Jones then initially filed suit against Perez, arguing his 4th and 14th Amendment rights were violated when he was arrested for capital murder. Perez claims that even if Jones' rights had been violated, she is entitled to qualified immunity. Qualified immunity doctrine always again. The district court concluded and Jones had not suffered a constitutional violations and granted the summary judgment. Okay, fair enough. Let's see what the court has to say. Kotaku points out the phrase one photo lineup is kind of inherently contradictory. Yeah, it is kind of contradictory. One photo lineup. Yeah, that's not really what the word lineup means, but yeah, carrying on. This whole process is a bit academic when the prior case law is applied to civil cases. Because a warrant is not a prerequisite to a lawful arrest, the ultimate inquiry for the false arrest claim is whether the arrest was reasonable. Arrest is reasonable when there's probable cause to believe a criminal offense has been or is been committed, warrant or no warrant, unless you're inside the home, as we have discussed otherwise. This is why our courts have, in civil suits challenging arrests, apply a third step after the traditional analysis. It asks whether any reasonably competent officer possessing the information each officer had at the time they swore the affidavit could have concluded a warrant should issue. The inquiry is the ultimate liability question in a false arrest case. Did the officer have enough information for probable cause, whether or not that information was included in the warrant? Okay. So when the district court properly reconstructed the affidavit or correctly determined the reconstructed supported a finding of probable cause, it's beside the point if Perez, at the time she swore out the affidavit, had probable cause to believe that Jones had committed the murder. So even though there might be other sort of offenses here, the question is the suppression. Right? The question is the suppression. The question isn't whether Perez committed perjury or deceived or anything. The question is whether or not the suppression of the arrest or suppression should ensue. And so that's under its own analysis. So whether or not Perez lied to the court is not the inquiry. The inquiry is whether or not the arrest could have been issued had they told the truth. The court concludes here that she did. Perez knew that Miller, who had stated that he witnessed the Miller, pointed the finger at someone named KT. Other witness was corroborated, and Jones admitted his nickname was KT, which reduced the importance of the photo identification and put the focus on whether Miller reliably indicated KT as the murderer. Perez also knew that Jones gave a false alibi, which is kind of important. In addition to showing that Jones had been dishonest about where he was on the night of the murder, his girlfriend's statements placed him near the crime scene, also pretty important. These facts are enough to clear the probable cause bar. Remember, probable cause is a pretty low standard. It's like 2 out of 10. So, it's not beyond a reasonable doubt. It's enough for arrest, not enough for conviction. That's not the standard we're trying to reach right now. The standard does not require the police officer to believe it's more likely than not. Instead, the officers must believe there's fair probability that the person did it. The fair probability of criminal conduct usually exists from a single statement of a single eyewitness, assuming no reliability concerns. The numerous problems with Miller's statement may well have reduced its reliability below that threshold, though it's a close call, as the district court believed it was still sufficient to establish probable cause. But then there's a false alibi and girlfriend's placing him near the scene. A false alibi, of course, is suspicious. This other evidence at least partially corroborated Miller's statement and put the overall evidentiary mix back at a lower probable cause. So even though the statement, on its face, even though the lineup, one photo or otherwise, on its face is below probable cause, this is a totality of the evidence. It's a total calculation. So this evidence by itself is weak, but it's corroborated by the girlfriend's statement that he was near the scene. It's corroborated by the false alibi. So is it enough for probable cause? Is it enough for a 2 out of 10 standard? Sure. Why not? Makes sense to me. Because Perez could have reasonably believed probable cause existed, the arrest did not violate the Fourth Amendment rights. The outcome of this civil suit may seem inconsistent with deterrent rationale of Franks. The conduct sought to be deterred in Franks is knowing, intentional, or reckless use of law enforcement personnel, false statements, and affidavits tended in support of such witness. But it is a product of a false arrest claim ultimately being about whether probable cause existed rather than the validity of the warrant. And the case also shows that civil litigation is not the only way to hold officers accountable for misconduct. Okay. Police officers can play a role too, as Dallas did in suspending Perez and removing her from homicide investigation based on the conduct. The judgment is affirmed. So that is our discussion of Anderson Jones versus Elena Perez. So what did we learn from this case? Well, we learned a couple things. First of all, the ultimate touchstone is that the arresting of someone must be done on probable cause, whether warrant or no warrant. That's the ultimate touchstone, the reasonableness of probable cause, according to the text of the Fourth Amendment. And so the question isn't what did the police officer tell the judge. The question is, did they have probable cause based on the information available to them? The court looked at the information that was available and said, yes, you had sufficient information to have probable cause. You didn't need to lie in what you told the court. If you had told us the truth, we would have issued you the warrant. And so this is basically similar to inevitable discovery doctrine. So there's a doctrine in Fourth Amendment law that basically says if the way you obtained evidence is illegal, it can still be admitted if you would have inevitably discovered it through lawful means. So if you had followed the rules, would you have discovered the information? If so, we're not going to throw out the information because suppression is such an extreme remedy because we're suppressing evidence that holds someone responsible for something they did. So using a parallel construction doctrine, if it was inevitable you would have found it, then we will allow it in because we don't want to let people escape justice from mistakes, even if they were intentional mistakes. If they had followed the rules, would we have obtained the evidence? If so, we'll allow the information in because suppression is an extreme remedy because it puts someone off the hook. So here I agree with the court. Regardless of whether the police officer lied or should have lied, they did have probable cause based on the evidence. So regardless of other things that should have been present, this suppression of the arrest is not a valid remedy under this circumstance. And the court notes that he was punished to some degree by the police department, and whether or not he should be indicted for perjury or other offenses is a whole other separate question not raised here, but that is not the valid remedy as it applies to this defendant because there was sufficient probable cause according to law. So I agree with the legal conclusions that are present here, and that is enough of this case.